let's see. Let's read, because I'll need to read this for tomorrow anyway, so. What's new? What's new on the docket, boys? What is, we're in June 2nd. Set the voice? Oh, set the lights. Oh, true. Reading lights for court docs. Absolutely true. Shh. Okay. Oh, they're trying to get it. Got to file. Oh, no, wait. That's May. Sorry. Just kidding. Oh, no. Okay. Got to get it filed right before the hearing. Okay. Comes now, plaintiff Jane Doe, by and through undersigned counsel, and respectfully requests the court enter an agreed proposed order to compel Lolcow LLC / Kiwi Farms to remove specified URLs that link to the video and for the imposition of costs and attorney's fees on defendant as follows. So we are trying to get a court order out of a case that doesn't involve these people at all, because they're not named anywhere in the complaint, to remove videos from the internet and then to impose those costs on me. Based request from the court. Plaintiff has been engaged in ongoing efforts to have the video removed from the multiple different platforms on which it was published, including the Kiwi Farms platform. Kiwi Farms is managed and operated by Lolcow LLC. The video was originally published on Kiwi Farms on November 29th, 2024. February 20th, 2025, 2 days after the complaint in this action was filed, the custodian of records of Kiwi Farms removed the original post of the video and replaced it with the following message. I don't like that they say this because I don't believe this is true. I don't believe that the original post, I don't have an account on Kiwi Farms, but I don't believe the original post was removed. Didn't they just put it behind an account wall? Like you had to have an account in order to view it? Or all my shit? So, but I like how they do this, but I understand it, Joshua. I know your game. That's cute. Try to play nice with the plaintiff to make me look bad. I'm here for it. I'm here for it. Putting the videos behind a registration barrier, in our opinion, will practice harm reduction by limiting the spread of this content to users already on Kiwi Farms who are participating in the discussion. Oh yeah, okay, so he said another thing. So the original post was not really removed. It was just, the original post was put behind an account wall or whatever. Although the original post, which included the link to the video, was removed by Kiwi Farms, the video resurfaced in multiple other posts on Kiwi Farms. Like, this is just a lie, but that's cool. Okay. Plaintiff had a subpoena served on Lolcow LLC on May 10th, 2025. The subpoena requested the production of certain documents and also the removal of the links to the video depicting plaintiff. Can you ask people, can you compel actions with a subpoena in terms of doing that? I don't know if you can do that or not. I don't know if they know they could do it or not, but whatever. Lolcow LLC / Kiwi Farms has cooperated with plaintiff's requests to produce documents and has expressed its willingness to remove all specified URLs which link to the video upon receipt of an order from this court. Lolcow LLC has reviewed the proposed order attached hereto in redacted form as Exhibit A and has stated that it will not object and will comply once the order. I don't even know if can they. I don't know how. Where are my lawyers at? How could they even object to the proposed order? They're not part of the case. We would get to object, which I'm sure we will, but it's not like they have to consent to the order, to the motion to get the court order. They're not part of this case. So, okay. Plaintiff is simultaneously filing a motion for leave to file under seal the unredacted proposed order, which contains the specified URLs that link to the video. Okay. Pursuant to the local rules, plaintiff met and conferred with the defendant regarding the incident motion. That's a lie. They never talked to us about asking for attorney's fees just for the removal of her video. Okay, that's an absolute fucking lie, but okay. Defendant does not object to the entry of the proposed order to compel Lolcow LLC to remove the videos. Plaintiff also requests, I don't think we actually reached an agreement on this, but I have to go back and read my emails, but plaintiff also requests an award of attorney's fees and related costs pursuant to 15 U.S.C. 6851, incurred as a direct result of defendant's unlawful disclosure of the video. Excuse me. This allows you to recover attorney's fees and stuff related to your claims under this. You're filing a court order to have videos removed from the internet. It's not related to this. And two, you're not talking about anything about the defendant, about me. You're trying to compel Kiwi Farms to do something. This has nothing to do with me. You can go around the internet and fight with whoever you want, but this is not, unless you're willing to name any of these parties in the complaint, which she's not because they're a coward. Plaintiff's expenses include legal and professional services necessary to pursue removal of the unlawful content from Kiwi Farms. What do you do? A boilerplate subpoena and a couple links to videos? How much money do you think you spent on this? Okay. Although defendant has averred efforts to remove the unlawful content, he has provided no evidence of such efforts and has not succeeded in having any content removed. Well, even on Kiwi Farms, which these guys should know because they rip half their legal defense from it. I did have... there was one email shot off to Kiwi Farms through my shit, but I know he's not going to ruin my stuff. He knows it's there. He knows it's not consented. He knows all of that. I shot an email. He didn't. He's obviously not removing any of my shit unless I literally file a lawsuit against him. But although defendant is the plaintiff was forced to act at her own expense to mitigate ongoing harm. Ooh, mitigate ongoing harm. Sounds like you are being actively harmed by somebody. Sounds like you should have a court case against them. Sounds like they should have been named somewhere on the complaint so that you could actually take real actions against them. Why isn't there a judge involved in this yet? There is tomorrow. We have our hearing tomorrow. Thank God. Thank God. The plaintiff was forced to act at her own expense to mitigate ongoing harm. The defendant should bear the cost of that mitigation. C. 15 U.S.C. Section 6851 B3AI. An individual may recover reasonable attorney's fees and other litigation costs recently occurred. Excuse me, that's if you win your case, and that's in relation to the claim against me. I don't know why they're citing. I don't know. Maybe her attorneys can't read. Like, I genuinely am not sure. Maybe they can't. I don't know. Wherefore, plaintiff respectfully requests that this court order Lawcal LLC to remove the specific URLs which link to the video on Kiwi Farms as set forth in the proposed order, impose attorney's fees and costs on defendant, and order any other relief it deems just and proper. Nice. Order granting plaintiff's motion to compel Lawcal to remove this cause can blah, 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 remove this stuff. And it's only her stuff, which is nice. Did they fuck up the redact? Oh my God, I don't, okay. Bro, what are these people? Okay. Can you at least proofread your orders before you submit them to the court? Plaintiff's motion to seal proposed order under seal per local rule 5.4. Is that the seal what we just read? Or... Pursuant to Local Rule 7.1A2, plaintiff met and conferred with the defendant regarding the instant motion. Defendant did not object to the proposed order being filed under seal. They're being really sneaky with their language here. We never agreed. We never agreed to any order that's going to have me paying their attorney's costs for court orders that are people that are unrelated to the case. But okay. Plaintiff's motion for protective order governing discovery by Jane Doe. Is there a certificate of conference? There might be, but they lie about what we talk about. I don't know how much I'm supposed to talk about what's being conferred about, but sometimes they just don't accurately reference what we talk about, so it's whatever, dude. Plaintiff Jane Doe's motion for protective order governing discovery. This is probably just whatever is comes out of discovery can't be like shown publicly, which I imagine is probably pretty standard. Wait, where the fuck was I? June 2nd. Oh, response in opposition to plaintiff's motion. Oh, that's us. Uh-oh. I don't think I've read these yet. Have I? Oh, I might have. Response in opposition. While Bonnell has no objection to non-party LawCal LLC voluntarily removing the video from its website called Kiwi Farms, after all, Bonnell did not publish the video to that website. Plaintiff's motion seeking a court order compelling LawCal to do anything is improper and must be denied for several reasons. First, as raised in Bonnell's answer and explained in his opposition to plaintiff's pending motion for preliminary injunction, this court lacks subject matter jurisdiction because the federal statute under which plaintiff seeks relief was not in effect at the time of the alleged dissemination of the video. This is still true. This is fatal to the entire case, but we'll see if maybe they've got another person to come out. Second, LawCal, a Texas-based corporation, is not a party to this case. LawCal is free to voluntarily remove any content from its site without a court order. True. Third, the request to relief is arbitrary and will not prevent the further dissemination or republication of the video on Kiwi Farms or any other website. True. The court order is literally just saying, please remove these things, and that's it. It's not an injunction or enjoining them from future behavior. They could literally remove all those things and just immediately re-upload it, and it wouldn't matter. It wouldn't do anything. It's literally a pointless fucking court order. It does absolutely nothing, but okay. Finally, even if the court compels LawCal to remove selective content, there's no legal basis to award attorney's fees or costs to plaintiff. Steve Bonnell is a live streamer, political commentator, known online as Destiny. Plaintiff also is an online streamer who uses the screen name Pixie. Bonnell and plaintiff met online, blah, blah, blah. Oh, these are some basic facts. Oh, this too. These guys just, dude. On May 10th, 2024, plaintiff served a subpoena on LawCal LLC, a Texas-based company that runs and operates the Kiwi Farms website. According to plaintiff, LawCal, quote, has cooperated with plaintiff's request to produce documents and has expressed its willingness to remove all specified URLs which link to the video upon receipt of an order from this court, end quote. To date, plaintiff has failed and refused to provide Bonnell with copies of any of the documents that LawCal produced in response to the subpoena. They're supposed to make these available to us, but again, they just like to, I don't know what the goal is, unless it's just to try to, I actually don't know. I don't know what the goal is. To get me to lie about something or to fuck up? Read the paragraph above about the Substack. On April 9, 2022, without identifying plaintiff, Bonnell transmitted the video to an individual named Rose, whom he met online. Apart from sending the video to Rose in April 2022, Bonnell has not sent the video to anyone else. More than 2 years later, on November 9, 2024, Bonnell learned that he was the victim of revenge pornography when a trove of his personal correspondence with third parties and sexually explicit content of his, including the video, was published without his permission or consent to a website called Kiwi Farms. Bonnell does not know the identity of the person or persons who leaked and unlawfully published his content on Kiwi Farms. Regardless, plaintiff published a lengthy statement on her Substack page in which she falsely accused Bonnell of intentionally distributing the video. She also posted about the video on her social media accounts and created a Give, Send, Go page to raise money to pursue this lawsuit against Bonnell. Okay. Well, I feel like we all know these facts now. Plaintiff's attorney, Joan S. Peters, indicated that LawCal, quote, has restricted the production of these documents to attorney's eyes only, end quote. Yeah, you can't, they don't have the authority. They don't have the authority to do that. But, okay. Without any protective order in place or any legal basis for the unilateral, highly confidentiality designation, plaintiff has taken the position that she, quote, can only share the Kiwi Farms production upon Bonnell's explicit agreement that it is for attorney's eyes only, end quote. Like, what? What is my lawyer, what is he going to do with anything from Kiwi? I don't know how much he knows about individual accounts. Like, what? But, okay. Further, In response to plaintiff's meet and confer efforts in connection with the instant motion, Bunnell inquired whether the motion was sufficient to prevent the republication of the video. Bunnell explained that the video was published on Kiwi Farms in response to other sexually explicit videos featuring Bunnell, having nothing to do with plaintiff. For that reason, Bunnell proposed the order include in her motion and proposed orders 26 additional URLs that link to sexually explicit content. Plaintiff refused to include the links Bunnell identified unless he agreed to pay her. True, and super fucking disgusting, but okay. Argument: the court does not have subject matter jurisdiction. Plaintiff alleges the court has subject matter jurisdiction because her claims arise under federal law, namely 15 U.S.C. 6851. Cardi provides remedies for conduct occurring only as of the effective date of the statute. A court must not give retroactive effect. Yeah, you can't have a retroactive law. Destiny. So their lawyers know you were a victim of revenge porn, but at the same time, they say you were the person who uploaded them. What is the point of this except maybe sharing it? It's because they're just trying to make me sound as bad as possible, and they're trying to like load on these other malicious claims because their underlying state claims require like a malicious state of mind, basically. And then they're trying to basically rope me into the damages of what would be the result of the guy leaking it onto Kiwi Farms and then Kiwi Farms proactively hosting the content knowing that it's revenge pornography. But if they can blame all of that on me, then they can claim all of the damages thereafter were my fault. So a lot of people seem to be under the assumption that like if somebody does a bad or a wrong and then somebody else takes those and then they radically morph them into more bads or wrongs, that the original bad or wrongdoer, allegedly or whatever, that is somehow responsible for all of the outcomes. But that's not really true. That's not really how the law works. That's not even how common sense works, but yeah. Here, Bunnell's sole transmission of the video preceded the effective date of Cardi by nearly 6 months. There is no admissible evidence in the record that Bunnell transmitted the video after the effective date of the statute because the date of transmission precedes the effective date of the statute. There is no federal question jurisdiction. Lolcow is not a party of the case. A court order is unnecessary. Plaintiff served non-party Lolcow with a subpoena in Texas. According to plaintiff's counsel, Lolcow produced documents in response to the subpoena. Supposedly, we haven't seen those, so no idea. Lolcow supposedly unilaterally designated its document production for attorney's eyes only. As such, plaintiff impermissibly refuses to provide Bunnell with copies of Lolcow's production. Also, according to plaintiff's counsel, Lolcow is willing to remove specifically identified content pursuant to a court order. However, plaintiff fails and or refuses to explain why a court order is necessary or how an order from this court would be binding on or enforceable against non-party Lolcow. It doesn't even make sense. Like, imagine you're talking to them and they're like, yeah, we understand that this is like non-consensual revenge porn, but we're only going to remove it if you shoot us a court order. Like, what? It's such a crazy, I don't know, whatever, but. Why did the judge grant the motion to file under seal? Unless something is exceptionally wrong, usually motions to file under seal will generally be granted. It's generally you grant these things, I think, unless you are doing something like exceptionally incorrect in filing under seal or whatever, or just like filing random stuff under seal. Was Lolcow even served with a notice of this hearing? How are they supposed to defend themselves? Why would they be served with any notices for hearings? They're not parties to the case. No, I don't think they have anything to do tomorrow. I don't think it's going to involve them at all, but. Plaintiff has not cited a single authority supporting an order compelling a non-party website operator to remove online content, whether styled as a motion to compel under Rule 37 or Rule 45 of the Federal Rules of Civil Procedure. There is no provision in either rule that permits a court to issue a mandatory takedown order against a non-party. It's just like basic, like, rules of civil procedure, I guess. I don't know, but whatever. Yet she seeks relief that is plainly injunctive in nature, right? I wonder what is the formal definition of an injunction? An injunction is a thing that enjoins. An injunction, I guess, is basically you've lost on the merits of your argument, and now you are prevented from doing some behavior, or you have to stop doing some behavior. But typically, this requires a court case to determine, right? An injunction can be given as a way to, if you've won a case, basically, but. Or an injunction might be able to compel some action as well, and not just enjoin an action, sure. Yes, she seeks relief that is plainly injunctive in nature without satisfying any of the procedural or jurisdictional requirements of Rule 65. The motion is in substance a veiled request for injunctive relief against a non-party and must be denied. Federal rules. Civil federal FS. I'm curious what rules does this govern. When you guys take the bar, are there really, like, Rule 65, are there really, like, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10? Really? I feel like I only ever hear, like, 4 civil procedure rules, but it's probably just because I haven't obviously done a lot of court cases or whatever. Contents and scope of every injunction and restraining order. Contents. Every order granting an injunction and every restraining order must A, state the reasons why it is issued, B, state its terms specifically, and C, describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. 2. Persons bound to the order binds only the following who receive actual notice of it by personal service or otherwise: A, the parties, B, the parties' officers, agents, servants, employees, and attorneys, and C, other persons who are in active concert or participation with anyone described in Rule 65D, 2A, or B. 65D, 2A, or B. Oh, that's this right here. So the persons bound parties, I imagine, are parties to the case, but whatever, based. Federal courts lack jurisdiction to impose injunctive relief against persons who are not parties to the lawsuit or shown to be in active concert with the party. This procedure strictly limits the reach of injunctive orders to parties, their agents, or those acting in concert with them who have actual notice. Plaintiff has made no such showing here. Her request to compel content removal from locale is not only procedurally improper, it seeks relief this court has no power to grant. Plaintiff identified a handful of URLs she's asking the court to order lolcow to remove from its website, yet plaintiff has failed to explain or justify how such an order would prevent the republication of the video on the QB Farm site or anywhere else online. Indeed, plaintiff's request is arbitrary and is not designed to prevent any alleged future harm. Plaintiff's cherry-picked URLs exclude links to sexually explicit content that Bonnell identified for removal in connection with the meet and confer efforts over this motion. Ultimately, plaintiff refused to include the links to the content Bonnell identified unless he agreed to pay her to do so. The relief plaintiff seeks is not only procedurally improper, but also substantively futile. Lolcow has already demonstrated its willingness to remove the identified URLs voluntarily, making a court order unnecessary. Well, that's not 100% true because they're saying they'll remove it, but they need a court order, which is retarded, but Joshua is retarded, so. Injunctive relief may be moot where interim relief or events have completely blah, 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 blah. Moreover, plaintiff's request does not address the core concern, namely that the video can be reposted elsewhere at any time. The 11th Circuit has consistently held that injunctions must be forward-looking, specific, and capable of enforcement. Injunctions regulate future conduct only. They do not provide relief for past injuries already incurred, and over with. An injunction must be geared towards preventing future harm. Plaintiff fails to articulate how the requested relief would prevent alleged future harm. Indeed, the content has already been published online. It can be republished on Kiwi Farms or any other website, regardless of whether the court enters the order plaintiff seeks here. Injunctions do not redress past harms or supervise diffuse, uncontrollable future conduct. And there's no basis for attorney's fees, argues that she's entitled to recover attorney's fees and costs from Bonnell in connection with this motion. Plaintiff provides no authority whatsoever for a position. Indeed, the undersigned has not found a single case in which attorney's fees or costs were awarded under similar circumstances. A final judgment has not been entered in this case, and certainly not one in plaintiff's favor. The court denied plaintiff's application for a TRO and has not yet ruled on plaintiff's motion for a preliminary injunction, nor has the court addressed the threshold issue of subject matter jurisdiction as raised in Bonnell's affirmative defenses and in opposition to the pending preliminary injunction motion. For all of these reasons, plaintiff's request for fees and costs must be denied, blah, blah, blah. Some of the court should deny plaintiff's request for fees because she has failed to meet and confer prior to seeking the requested relief. Outrageously, plaintiff's counsel provided the undersigned with a different draft of this motion than the one she ultimately filed. Nowhere in the draft motion that plaintiff's counsel provided, nor anywhere in the meet and confer correspondence, did plaintiff's counsel ever mention that plaintiff would be seeking attorney's fees and costs. Bonnell would have objected to the motion had it included a demand that he pay plaintiff's legal fees and costs in connection therewith. For plaintiff to sandbag Bonnell by seeking fees and costs without ever raising the issue as required by local rule 7.1, subsection A2, smacks of bad faith, provides an alternative basis to deny the fee request. They typoed my name. No, Bonnell with one N. Well, Bonnell does not object to the voluntary removal of the video or other sexually explicit content in which he and or plaintiff are depicted because 1, the court lacks subject matter jurisdiction, 2, lolcow is not a part of the case, 3, okay. What's next? Oh, a declaration by my lawyer. I'm an attorney admitted to practice pro hac vice, I think, in the above caption action. Blue, blue, submitted attached here is Exhibit A is a true and correct copy of the subpoena. B is correct. Declarations. Emails. Oh, this is the subpoena that they served to Kiwi Farms. Okay. Exhibit B. Emails. From Joanne, or Joanne. Andrew, as you are aware, we served a subpoena on Kiwi Farms. Kiwi Farms has responded, and we have received a response in partial production. We should be receiving an additional production in the next few days. Kiwi Farms has restricted the production of these documents to attorney's eyes only. If you accept this restriction in writing, we will arrange for the documents to be shared with you. I'm also writing as a meet and confer on the following. Kiwi Farms has consented to removing various links to the video pursuant to a court order. We will be filing a motion requesting the court to enter the proposed order agreed, or the proposed agreed order. Do you have any objection to the same? Please advise by noon EST tomorrow. Thanks. Please send the Kiwi Farms production. Also, please provide us with the unredacted declarations in light of today's order from the magistrate. As I already stated, I can only share the Kiwi Farms production upon your explicit agreement that it is for attorney's eyes only. Otherwise, I do not have authority from Kiwi Farms to share. Authority from Kiwi? They're not. They don't. That's the authority doesn't come from them. It would come from the court. You have to. There's a motion to the court saying that sometimes you can have documents that are for attorney's eyes only, meaning neither the plaintiff nor the defendant can actually look at these documents themselves. But that comes from a court. One side can't unilaterally declare that, and certainly not a subpoenaed person can say, "Oh, I'll share this with you," but only if only the attorneys can. Like, you can't. You just can't do that. You're just stupid. Whatever. Oh, geez. Oh, I think I already went over these. These were on another thing on stream, right? We asked them to basically saying like, okay, well, if we're going to file a court order in this case to take down explicit videos, then here's all the explicit videos. Why not take them all down? And then they said, we did a quick review of these links. Only one of them includes our client. Kiwi Farms has only agreed to remove links to videos that include our client. Why do you think Kiwi Farms gets to choose? If we're going by what Kiwi Farms is consenting to, then why the fuck are we even wasting our time with a court order? All of this is so stupid. Oh my God, all of this is so stupid. Kiwi Farms only agreed to remove links to videos and include our client. I will ask their counsel now if they will agree to removing this URL as well, because it includes the plaintiff. Andrew, I explained to you what these links were. It appears that people have posted the video in response to other sexually explicit videos featuring our client having nothing to do with yours. For that reason, we would like to include additional links among the list of URLs in the proposed order. I understand that there might have been postings of the video in response to other sexually explicit videos of your client, but the links that you sent do not include any such postings of the video and have nothing to do with our client. On behalf of our client, we spend a significant, amount of time, effort, and expense in subpoenaing Kiwi Farms and eliciting its cooperation. So they mean 3 emails, in the removal of the links to the video. If your client would like to reimburse the plaintiff for the legal fees she has incurred to date regarding the removal of the video from Kiwi Farms, we would consider including the links to the videos of him in the proposed order. Like, seriously, dude? Otherwise, he will have to expend his own resources to have his own content removed. We need to take care of our client, and so we will proceed with the motion as is, which you have already stated that you do not object to. And then we didn't even have a copy of the motion, I think, at this point. Here's the draft motion and the draft proposed order. Holy shit. Oh, I actually hadn't seen this. They actually sent, they sent us a different, come on. At what point do you get, I keep saying like sanctioned or reprimanded. I'm sorry, hold on, wait. Maybe I'm reading this wrong, wait. Wait. So this is the order that they asked us if we consented to. It's got 1, 2, 3, 4 points. The fourth one is defendant does not object to the entry of the proposed order. It says that they are going to produce documents. It says they're going to remove the video. This was so they're supposed to send you a proposed order. And then you say, do I agree or do I disagree? And then we're like, okay, fine, we agree. So that they can file it with the court and that it's unopposed by us. Or you can even generally file a motion if you want. And then the court will just fast track it. They'll agree with it. It's because there's no opposition to it. This was the proposed order that they sent to us. And then the order that they filed with the court, they added on number 5. They added this on. Plaintiff has also requested attorney's fees for our court order. Jesus Christ. Bro, come on. What is this? Every federal court I've been in front of would have sanctioned an attorney for this sua sponte. I don't even know what that means, but Jesus, that's actually gross. So like, what is the goal here? So like, let's say for instance, my attorneys weren't paying attention or we like fucked up or something and then we approved and we don't oppose this motion because we've already gotten a copy of it. Now, obviously, thank God, we're doing our due diligence and reading the submitted orders. Would we have just been on the hook for whatever arbitrary fuck number they would spit out at us here? Like, oh, so all of our legal fees so far have gone, like, sua sponte equals court will do something on its own without the need for a party to file a motion. Oh, I doubt, Kafka, my guess is going to be that the judge is probably very quickly glancing over these. I doubt that they're like hardcore because we haven't had like enough. Well, the only hearing so far was the TRO. And our first big hearing tomorrow is with the magistrate judge, not the actual one. So my guess is they just haven't like been reading these in depth. That would be my guess. But Jesus. Okay. That's tricky. Nice. We're learning some. This is the Better Call Saul stuff. Okay. All right. Based. Response and opposition. Is it, wait, did I read this one already? Was this our? Okay. Oh, this was our, okay. Declarations from my attorney. Yeah, okay, we just went over these. Cute. Okay, so there must be something juicy in here because these motherfuckers, these guys file everything at the last fucking moment or they file it late, right? So they have, their replies to this were due by the 6th, but they actually filed their reply today, probably because they want this in the record for the hearing tomorrow. Destiny, respectfully disagree. Federal courts are notorious for reading everything. I bet there's a lot of pity coming from the bench. They see how bad the case is and out of how to death plaintiff's counsel is. On top of that, there's a lot of potential publicity that could come in this case, so they fuck up an appeal. You think so? I don't know. I guess we'll find out. Okay. Let's go. Subject matter jurisdiction. That's the big one. That's the important thing that they have to prove. So, damn, a 10-pager. Whew, they busted their balls to get this out tonight. Okay. Defendant Stephen Bundle II is a prominent online content creator and live streamer with over 840,000 followers. Since the initiation of his lawsuit, defendant has repeatedly discussed and published details of the litigation on his public platforms, including the pleadings, counsel communications, and meeting confers, the names and home addresses of counsel, and even settlement. Excuse me, all of this information is public. It's literally at the end of all of your The names and home address. Well, what home address? It's just whatever's at the end of your. Is this illegal? Is it illegal for me to show the the public filings? Hello? Is 10 pages the limit, or do they need to ask for extra? No, 10 pages is your ordinary limit, I think. Jesus. I'm fucked. I doxed them. Shit. Okay. And even some discussions, he's also made derogatory and intimidating statements about the plaintiff. I can make derogatory statements if I want. This is a free country, baby. Intimidating statements? What? And statements about the plaintiff, her counsel, plaintiff's witnesses, and her prospective witnesses? Bro, you filed the lawsuit like what, 4 months ago, and you're looking at so what? I can't say anything bad about everybody on planet Earth because everybody on the planet could be a prospective witness. What does that even mean? Okay, damn, that's based legal tactics. Okay. Indeed, several witnesses, including those that provided declarations in support of plaintiff's motion for preliminary injunction, have expressed fear of being publicly targeted or doxxed. This is not a real thing for the court. What do you publicly targeted by defendant and or his followers and have indicated that they are unwilling to participate in discovery or testify unless their identities remain confidential. Oh my God. What? I'm sorry, but like we're in the big boy world now. And if you want to be a big boy and you want to come and do court stuff, that's fine. But we're going to move past this is my Twitter account and this is my Reddit account. And now we're using our real life identities because we're doing a real life court case. All right. You have to decide if you want to do big boy things or if you want to shitpost on Twitter or Substacks. You can't have it both ways. You have to put your big boy pants on and you got to go to court and you have to say, this is my name. This is what I'm testifying to. That's what we do here. Like, Jesus Christ. See plaintiff's declaration attached here too as Exhibit A. For this reason, the witness declarations were filed under seal. Based. Okay. Plaintiff is requesting that the court enter the narrowly tailored proposed protective order attached here to as Exhibit B to protect the integrity of these proceedings and prevent a chilling effect on evidence gathering and testimony. Why don't you already have this? We're 4 months into the case. How do you not already have all of this by now? What do you, like, you haven't, it's not like you're serving discovery requests to us and those people are denying things. Like, what the fuck? This order would apply equally to all trial participants and serve to prevent further public doxing, harassment, intimidation, and misinformation. Without a protective order defends continuous extrajudicial comments. I'm reading I'm reading your filings. What? On his streaming platforms, over 840,000 essential likelihood of materially prejudicing this proceeding. Relevant facts. Defendant has publicly threatened physical harm to individuals that have spoken out against him and in support of plaintiff. For jurisdictional agreement, I'd kill him if I could. I'd show up to the fucking house and do it. I do want somebody to kill. Oh, we got the bold and underline. We got the bold and underline. These two people, none of these people are involved with this case. Why? I don't understand why they've mentioned them in like 15 different court docs. Jesus. Each of these individuals are potential witnesses? Bro, what? It's like Agent Smith. What? How do you not know if they're a witness yet? What? In this action, due to their knowledge of the facts and related interactions with the defendant, indeed, Lav is included in the defendant's initial disclosures as an individual likely to have discoverable information. Then serve her with a subpoena. Why would you? Don't even make it. Also, by the way, they publicly filed this initially, which was funny and a fuck up. But why are you? Then you don't have to serve me with that discovery. You could just serve that other person with a subpoena. No. The defendant has tried to dox. This is so cringe. Doxing is not a thing in big boy world. People use their real life names and their real life, sometimes their home addresses, which mine has been exposed multiple fucking times in this court case. If you want to do real life big boy things, then you have to do real life big boy things. You don't get to use a Discord username and my address is the Discord user. Like, yeah, show up or fuck off. What do you mean? The defendant has tried to dox both Queeman and Jessica on his platform. These people are not parties to any of this case. They're not parties to the case. See also Google Drive and Shamu UIT Twitter. Those are his intentions. Thank you for the Twitter links. I can't wait for the judge to be clicking these in court. What is this Google Drive link? Hold on. Sorry, the file you've requested does not exist. Okay. Based. The term dox or doxing means to publicly identify or publish private information about someone as a form of harassment or revenge. Does it count as doxing when they provided service to me at my home address and my address is published, or? Okay. Defendant regularly streams on YouTube channel. The details of this case included confidential details from meet and confidential. What are you talking about? No, we haven't decided. Nothing that has been, if anything has been sealed or redacted. I haven't discussed those things. After plaintiff's reply to the opposition to motion for preliminary injunction was filed, he streamed about the filings, showing them on his screen, reading excerpts aloud, and providing vitriolic and defamatory commentary for over an hour. Sometimes these are not confidential. These are court filings. These are public filings. Am I not allowed to read the public filing? Also, I'm allowed to say vitriolic, well, defamatory is an opinion. It's my court case. I'm allowed to say whatever I have a First Amendment right. This video has been viewed 120,000 times to date. In it, defendant accuses plaintiff of extorting and blackmailing him, of insane lies, of a total lie. Okay, is any of this illegal? Okay, all right. In the same video, defendant accuses plaintiff's witness, Abby MC, thank you for redacting her identity, good job, of lying and perjury. He refers to the undersigned counsel as disgusting fucks. True. Oh, they're personally offended. Get mad. Joanne, if you're reading this, you are disgusting. You are a disgusting, horrible person. You are. I hope you know that. And I feel that way personally about you. I'll make a declaration to the court if I need to as well. He refers to the undersigned counsel as disgusting fucks and repeatedly accuses the undersigned counsel of grabbing random people to perjure themselves. Defendant accuses plaintiff's counsel of bad faith arguments, explicit lying, and abuse of the court system. True, true, and true. He spends a full 30 minutes telling his followers that plaintiff's counsel has no understanding of the federal rules of civil procedure. They're so ass-paid. Why are they putting this in any of these filings? It has nothing to do with this case. She's actually mad. She's actually mad.
Bruh.
She's like rage posting on the filings. They have 10 pages. They have 10 pages to file for their client. And Pixie's like, can we include this? She's like, no. She's like, and then he said that I was a fuck. He called me a dumb fuck. And he said I didn't even know the federal rules of civil procedure. Defendant accuses plaintiff's counsel. Okay, he spends a full 30 minutes telling his followers plaintiff's counsel has no understanding of the federal rules of civil procedure because they allegedly did not adhere to proper procedures by filing redacted declarations of the witnesses, along with the motion to file under seal, the unredacted versions. Defendant, of course, is wrong since the court granted plaintiff's motion to file under seal. So this would be a bad faith argument. It would be explicitly lying, and it would be abuse of the court system. I like how they did all three right here. My issue is not you filing things under seal, and you know this because of our own filings. The issue is you thinking that you can file things under seal while keeping those private from us. You're not allowed to do that. Kind of like how you showed us a motion, asked us to agree to it, and then you filed a different one with the court. That's an example of explicitly lying and abuse of the court system. Jesus. Defendant, of course, is wrong. This type of misinformation about the litigation on his platform is rampant, and based on the thousands of comments on the YouTube video, is accepted as gospel by his followers. Disturbingly, all of this extrajudicial commentary is approved by defendant's counsel. Oh, they love throwing this one in. I pass everything that I publish by my lawyers first. When I made this comment, when I say publish, by the way, I'm talking about the, I think that initial manifesto or whatever that I did. It's not like I script out all my live streams and YouTube videos. I don't know why I'm saying this. They know that. They're just fucking, but okay. Good one. Jesus. The defendant has also told his followers on Kiwi Farm. Are we just linking? What the? Bro, I told you they were getting their arguments from Kiwi Farm. Are they just straight linking to the farms now? Hello? The defendant has told his followers on Kiwi Farm. The Kiwi Farms are my followers. The witness Abby is crazy and insane / unhinged. He also informed his community of the name of Abby MC's prior boyfriend. Because it's public knowledge. They stream together. We've all seen it. What the fuck? Oh my God, bro. The defendant has also publicly doxed and attacked Lauren Hayden. When did I dox her? I can't dox her. I don't even know where she fucking lives. Where the fuck can I? Wait, is Lauren writing all of this? There's no way, right? There's no way that the other lawyer from Puerto Rico would just hand over the docs to her, right? Or that like Lauren is working for their office, right? That would be they would be conflicted out. There's no way. How have I doxed Lauren? They defined it differently in the document. Lauren Hayden, a friend and potential witness of plaintiffs. Lauren is listed as an individual likely to have discoverable information on defendant's initial disclosures. If she's your friend, then you don't need anything from me. She's gonna have all of the information herself. Why do you even? I think actually initial disclosures is disclosing to me who might have information, but like, she literally put her name on the GoFundMe. Like what the fuck? She had her fucking name on the Give, Send, Go. I think her name is still there, isn't it? Give, Send, Go. Am I about to dox her again? And her middle name. Did I just dox her? I'm sorry. What? The defendant has spread lies about Lauren and talks about you're lying to get this part because she's been supportive of plaintiff. What? Why is this even being included? You're wasting hold on. I just wanted two things. There's two things that are happening here, okay? There's two things that are happening here. Why I think this is gross as a non-lawyer and a non-person or whatever, right? So maybe what I'm saying is retarded. There's two things that are happening here. The first is a party I have no sympathy for now, which is Pixie. You're wasting her time and you're destroying her fucking life. Because as mired in conflict as I am right now, I can still stream and make money and do all this bullshit. My guess is Pixie is probably fucking hanging on by a thread based on the outcome of this particular case. That's my guess, just based on recent tweets I've seen from her that are all public, right? So the fact that you are wasting time from your client, you're wasting time from your client to throw in random shit about, again, a non-party to the case. Lauren Hayden has not made any declarations to the court. She's not a witness to any of this. She's not, like, why are you wasting your client's time on this? Number one. And number two, the party that I do have sympathy for is, why are you wasting the court's time with this? Like, you already elected to file this in federal court. You wanted to go to big boy federal court. So now we're on a federal docket, eating through a federal judge's time that I imagine probably have real cases to hear and important shit to hear, even of these same Cardi claims. Like I said, if you go and read the underlying cases, these are some crazy cases. Like, the defendants are genuinely fucking unhinged and crazy. But now you're wasting a judge's time to go through your MySpace shit posts? Like, what the fuck is wrong? Why would you do this? So now we're going to go and bicker in front of a federal judge who's supposed to play therapist? It's just disgusting. It's so gross to me, but whatever. Would your lawyers have been able to file an objection to this motion if they hadn't filed? Well, this isn't, I don't think this is a motion. This is a filing in support of their other motion, right? Motion for protective order governing public commentary. Oh, this is a gag order. This is a new motion. Damn, we got a lot of motion in this case. Jesus Christ. Does this Google Drive link work? Hold on. This is from 2025, February 19th. I'm not 100% sure the majority of this was pushed by Lauren Hayden. If I could get her disbarred for this, considering she already failed character and fitness once, LOLW, it would be chef's kiss. True. Wait. She filed her case on February 18th, right? Why are you using the fact that you provided declarations, meaning I shouldn't be attacking Lauren, and then providing a statement that I made before any of those declarations had ever even been made? Oh, okay. Jesus. Also, the defendant has spread lies about Lauren and talked about how he likes to get disbarred because she's been supportive of plaintiff. Not because of the fact that she's... you said I accused her earlier of lying and all those other things. Don't you think that has more to do with... I'm sure there are people that are supportive of plaintiff that I haven't besmirched. You want to be supportive of plaintiff, then whatever, fucking knock yourself out. I don't give a fuck. My issue are with the people who are doing bad things. Furthermore, despite the protective order entered by this court... This is a gag order. Hold on. Imagine the audacity of trying to gag me after you made a fucking public post detailing everything about the case. It's so disgusting. Holy shit. I'm actually triggered. I want to do a public gag after you published your whole ass insane because now you're not happy that you didn't find anything. Now you're not happy about the public filings. Now you're not happy about how the court case is going. Like, give me a break, dude. That's so wild. But furthermore, despite the protective order entered by this court to protect plaintiff Jane Doe's identity, defendant publicly disclosed plaintiff Jane Doe's legal name on his YouTube platform. First of all, I think this was literally the same day. Number one, I removed that name. Number two, plaintiff literally listed her name on the fucking GiveSendGo when they published it. So the plaintiff has already made their name public. All of the damages associated with this case even have nothing to do with plaintiff's name. It has everything to do with her identity, which is Pixie, and she's using her online name and everything anyway. I feel like this entire court case is just like trying to like lay traps and then see if I fall into the traps. And it's like, Jesus. How do you not file this motion at the start of the case? True. There's a lot of stuff like the TRO, for instance, that they should have. After plaintiff brought this to the attention of the court in her reply to the opposition or motion for preliminary injunction, the defendant removed the reference to plaintiff's legal name. However, defendant did not delete another reference he made to her name at minute 11:34. But why not ask me? Meet and confer. If you know there are additional mentions, I deleted the one they asked. If there were additional mentions, then just request it and it'll get deleted. What, do you think I want to mention? No, this is a spite. Why would you hold on to this for 4 months if you actually gave a fuck about your identity? Why are you holding on to this? Moreover, in the chat thread that accompanies this video, after 7:58, his followers then repeatedly refer to plaintiff's name. Why are you listing this in a public filing if you give a fuck about your name? So like, I could theoretically, I guess I won't show it on stream, although I don't know why not, because it's all in a public fucking filing. Why would you include this? So now that if you're just, why would you do this? What the fuck? Oh my God. Defendant did not remove those comments containing plaintiff's name, and so they are still public. These actions are meant to defeat the protections afforded to plaintiff of filing as a Jane Doe. You defeated those protections when you literally launched a Substack identifying yourself in the videos, and then launched a GiveSendGo that was attached to your real life name that was all public facing. Come on, give me a fucking break. This video's been viewed over 130,000 times. In the same video, defendant posts plaintiff's private messages to him about her emotional distress and suicidal thoughts due to his non-consensual sharing of the video, and then mocks and ridicules her. He then tells his followers plaintiff's emotional distress subscribed solely for the purpose of extorting him. Well, technically, there was another person that claimed that in response to Pixie's messages to them, but yeah, no, don't hate the messenger. Numerous individuals initially contacted plaintiff with information pertinent to this action, but have refused to provide testimony due to fear of retaliation and or doxing by the defendant. What? Can I make shit up? Where's my lawyer? Am I allowed to just say this? I've had 50 different people tell me that plaintiff is actually engaged in all sorts of bad, but they don't want to say it. They don't actually want to come forward and identify themselves. They don't actually want to put that in writing anywhere. This is hearsay. And in some cases, this is double hearsay. Like, why? Like, they're not even present. See Exhibit A. Besides the 3 witnesses who have provided declarations under seal, by the way, none of those 3 witnesses, well, technically one of them is actually relevant to the case, but no evidence has been provided for anything they've said. Out of the original multitude of individuals who initially contacted plaintiff, there are now only 3 with whom plaintiff still has contact because the majority deleted their accounts after Destiny posted his video on YouTube titled Destiny Addresses His Lawsuit on February 20. Wait, so you're telling me that you made a Substack in January, you had people contact you, you didn't take down any names, you didn't take down any statements, you didn't get them to sign any affidavits, you didn't verify anything they fucking said, then you filed a court case and you went back to look for them and their accounts were gone? Are you fucking crazy? This is insane. Do you even know if these people were fucking real? Or is it literally, did Kiwi Farms literally troll this dipshit into filing a court case? Are you fucking serious right now? What? The fuck? The 3 individuals with whom plaintiff still has contact have told her after that they are afraid of speaking out or testifying against anyone because bullshit! Because I see Stacia is her online name, and I see Hannah posting every single fucking day in other people's Discord chats about all of this. They're clearly not afraid. They're clearly not intimidated. They talk all the fucking time about this, constantly. They can't help themselves. They can't help themselves but constantly talk about all of this. What are you talking about? Jesus. Federal Rule of Civil Procedure 26C specifically authorizes the court for good cause to issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense upon motion. Check Exhibit A before finishing. Why? I'm trying to... What? Are you spoiling? I, Jane Doe, declare as follows. I'm over the... Who is this? Hold on real quick. I won't say the name, but I'm curious, did we actually get any copies of any of these? Or am I going into my hearing tomorrow with absolutely no fucking idea who any of these fucking people are? Let's see. Don't have it there. What about this? Nope, that's redacted. Redacted. That's so fucking great. That's nice. Cool. So I get to go into this hearing tomorrow. I have no fucking idea who any of these... Okay, cool. Base. Well, let's see what they say. Maybe I'll know. Maybe I can figure it out. Not that I would identify them publicly. That's not Exhibit A. Attachment 1. Oh, Exhibit A is down here. Oh, too late. We're reading this anyway now. Personal knowledge matters here, and I called it. I'm testifying in declaration in support of Linda's motion protective order to govern you. I contest the fact that defendant Stephen Bonnell's actions have interfered in the willingness of witnesses to come forward and testify in this action. Oh, this is just Pixie? Why does she not say, am I not allowed to use the online name anymore? When I first publicly announced in January of 2025 that I would be taking legal action against the defendant, numerous individuals contacted me with information they believed was pertinent to the case. The majority of these individuals informed me that the defendant had sent them pornographic content involving other individuals without the individual's concern or knowledge. That has nothing to do with the case. That's not pertinent. That's not relevant to this case. Why are you even including this? One of these individuals, whose screen name was XXXXXX, told me the defendant sent the video depicting me to their sister. Is this double hearsay? What? This individual and their sister, as well as other individuals who had initially contacted me, completely deleted their accounts. Dude, are you actually fucking serious? Is this this has to be a fucking troll. This can't be real, right? This has to be a joke. This individual and their sister, as well as other individuals who had initially contacted me, completely deleted their accounts after Destiny posted his video on YouTube entitled Destiny addresses his lawsuit on February 20th, 2025. I legitimately, you know what, also, props to, you know what? The farmers are a brave people. Good job. Good. It was an epic troll. Epic troll. In this video, the defendant further violates my privacy by publishing to his almost 1 million followers out of context private messages. Oh, I'm sorry. Do we need more context with the private messages? Out of context? I'm sorry. Is Hassan suing me now? The three women that provided declarations under seal and support of plaintiff's motion for preliminary injunction expressed fear of being publicly targeted or doxxed by defendant and or his followers and indicated they're unwilling to participate in discovery or testify unless their identities remain confidential. Well, but two of these people, the Hannah person, for this reason, the witness declarations are filed under seal. Well, Hannah's wasn't. And then you put the screen names of, bro, this is so, oh my God, dude, get me out of here. Get me the fuck out of here. They talk about this shit daily. I have so many screenshots too. That's going to be wild. So here are the people, by the way, who are afraid of talking about testifying. But let me tell you, Judge, Your Honor, look at all the testimony that they're okay leaving in this other dude's Discord server. Besides these three witnesses, there are 4 additional witnesses I have contact with, but they have told me that they are afraid of speaking out or testifying against the defendant because of his likely retaliation and harassment. Attached here too, as Exhibit A, is a true and correct copy of one of the witnesses named XXX, who has communicated to me her fear of defendant. Okay, Exhibit A. It's just that I don't have money for a lawyer or anything. Once he knows my name or something, I'm afraid he's going to harass me or get others to do so. Well, what would they even need a lawyer for if they're just a witness or declaration? Well, also, this is on January 22nd before I'd even released that YouTube video. As well as individuals who initially contacted me completely deleted their accounts after we posted this YouTube video on February 20th. They literally told you this on January 22nd. What even is this screenshot? What is this? I don't know. I can't know who these people are. I'm not allowed. Why do they keep filing secret evidence? Ignore everything. I'm so fucking retarded, okay? This is the difference between being street smart and being book smart, okay? Because I read all this boring, stupid legal shit, okay? But then when you look at how Trump's lawyers argue, the Solicitor General argues in front of the Supreme Court, okay? Or you see these arguments, none of that actually matters, okay? All of that was cucked and bullshit. All of it was cucked and bullshit. This is street law. This is the real shit. I have no fucking idea what this message is. I don't know who it's sent. I don't even know who it's about. It doesn't even mention my name. I don't even know what the fuck this is. Destiny has tried to repeatedly dox one of these witnesses, whose screen name is X, after he publicly expressed his support for me. This potential witness will not testify to pertinent information regarding the case unless his information can be protected. Blankus expects to be providing any further information after defendant publicly called for his death on the defendant's YouTube channel. Why would you? Okay, so it's either it's one of two people. Attached to his Exhibit B is a true and correct copy of his communication to me expressing his fear of defendant. Let's see if we can figure out who this one is. Let me get a drink. like, it's only funny because I'm rich. Like, dude, if I was in this financial position I was in, like, even like 5 years ago, this would be legitimately like a horrific experience. This is just like, this is insane. And then also, like, this is funny. I wish I knew more of like the sanctional arguments. Like, her attorneys, I think, should be like severely reprimanded, because let's assume that this was an ordinary Cardi case. Let's assume this was a case where this federal law is usually invoked. I've said this before. I think we've gone through one or two of these on stream. Somebody can link me a Cardi case if they want. The defendants are actually fucking crazy. These men are insane. They're shooting these videos, sometimes on alternate accounts, to plaintiffs' friends, family members, coworkers. They're crazy. A lot of these defendants are, right? If you want to litigate a case like this that involves relatively sensitive information, if you're not qualified to do the case, then pass it over to someone who is. There must be some rule against, like, let's say I go to the fucking University of Law School of Nebraska and I pass the bar or whatever, and then some guy like says, can you be my defendant for like a quadruple homicide rape case? And I don't even know anything about it. I'm like, yeah, let's do it. Like, I'm pretty sure you can, I think that's like I don't think you can do that. You must not be able to. I'm saying I'm just relying on common sense. Like, maybe you can. Like, this is, like, imagine if I was the unhinged person that these people say that I was. You've leaked so many identities to me. You've leaked so many of these identities. And you're not even using the correct blackout tools. You're not even using the right, it looks like did they color over this with a marker and then scan it? I don't even know if they actually just... This has to be a setup, right? Like, the only reason why they're doing this is, yeah, I think the whole case is just trying to get me to fuck up because they know they have no case. So it's just wasting my time, wasting my money, destroying my reputation, trying to destroy my life. It's just, that's the goal. It is literally, as much as I hate to say it, it is the red pill nightmare scenario of like the actual hardest case scenario of that. Why the hardest case is going to be accusing me of rape, but. Why did they black out her avatar but not redacted? I don't want to say his name. Do you mind if I say I sat down with your attorneys? Yeah, sure. What day / what for exactly? I just wanted to say it today. Brettler just filed a motion in opposition. And I'm going to say this is precisely why I refuse to give an affidavit, because Doxing himself was listening, calling for my death is too much. Wait, are they plotting and scheming behind the scenes on how to do, and she's trying to gag me? She's filing a gag order against me while she's literally working behind the scenes with this guy to try to optimize for his coverage? You understand that? I feel like Ethan Klein, dude. This is like my biggest like paranoia conspiracy, right? Although I already had this basically confirmed on the day that the Give Send Me Go was made, and I saw Lauren's name on it. I was like, that makes sense, right? Jesus Christ. And I'm going to say this is precisely why I refuse to give an affidavit, because doxing myself plus Destiny, calling for my death, is too much. But if I've already done this, then why do you even care? What, like, Your Honor, yes, my name is Stephen Bonnell, and I'm from Miami, Florida. What brings you to court today? Your Honor, I, Stephen Bonnell, who lives in Miami, Florida, does not wish to give any more commentary on this because I don't want people to know my name or my address. Thank you, sir. You're dismissed. Like, Jew Stalker show this on stream today? What did he say? What? Is Brettler Destiny's lawyer? Yes. Are they taking turns getting the 10-page motion written up? This is them admitting to just go lying, right? Oh, why? Are you assuming this first statement is a lie? Do you mind if I say I sat down with your attorneys? I don't know if this is him implying that he actually hasn't sat down with his attorneys or her attorneys. It could just be him saying, can I have permission to say this on stream? Ooh. I'm making a bit of an assumption here, but I'm so curious if Lauren is the one that's quarterbacking this case, because he asked her a question. Do you mind if I make a public statement about the case? And she answered that statement in 1 minute. How did she know the answer to that? So if I imagine that she'd probably text or email her lawyer and ask, is it okay if this guy makes this statement with regards to Destiny or whatever? But she had the answer instantly. How? This is them explicitly saying they're falsifying a claim of witnesses. Wait, how is it saying that? He sat down with the attorneys. He's asking his chill to let his stream know. Well, no, I understand. That's what I am interpreting this as. But why was she able to answer in the affirmative in 1 minute here? Would she have actually cleared it with her lawyer first, though? I thought about that, but what would that even look like? Do you think that if you ask your lawyer, hey, just checking, if any of the witnesses want to make public statements about any of the things they've said with you, are they cool for that? You think any lawyer would give a blanket yes on that? No shot. 0% chance. Because remember, attorney-client privilege, and I imagine that extends to witnesses because your attorney is an extension of yourself. Attorney-client privilege is one of the things that I don't get access to. I don't know what you tell your attorney. So the idea that she would get a blanket authorization from her attorney for people to leak what they conferred about or what they spoke about, I don't believe that. That's crazy. Oh, wait. Could that be it too? Oh, hold on. I don't know. Oh, wait. Hold on. Oh, God. Wait. The conspiracy brain. Wait. Do you mind if I say I sat down with your attorneys? And she says, yeah, sure. What day / what for exactly? Did she misread this as him saying, do you mind if I sit down with your attorneys? And she was asking, oh, that would explain the instant response time. Oh, shit. Wait, so do you think this means she could have interpreted it as him asking for a second meeting? I just wanted to say it today. Oh, shit. It means he didn't sit down with them, but he wants to lie that they did on stream. That's what it looks like. Now, maybe he met with them one time and he wanted to, and she thought he was asking to meet with them a second time. Well, actually, wait, that's easy to figure out. You should subpoena his logs. I already requested that in Discover, I believe. I doubt they'll produce it for me since they don't seem to be giving anything else, but I think that's one of the reasons why he was spooked. Not because of any public threat I've made, but because he would have to actually provide proof for the things that he's been doing. And I imagine what he's probably doing is running around actually deleting all of his evidence and actually deleting all of his logs and actually trying to hide as much as he can. But he thinks because he's in Canada that he's safe from it all. That's my guess. That's why he doesn't want to be officially involved in this case.
Exhibit B. Hold on, let me pull up Exhibit B here. They've gone to great lengths to protect this clearly heroic individual's identity. So let me just see. Oh wow. I don't know who this could possibly. You know what? I'm glad that they protected this person's identity. They could really be in a lot of trouble. This person's apparently been threatened. Whoever this person is could have been in a lot of trouble if their identity was exposed.
Now it's funny that he's laughing joking. Remember, initially I was basically a serial rapist, okay? Then when the case was filed, well, I had lied about ever having a single law firm, let alone multiple law firms, that I had retained for this. And then it was, when it took me too long to respond, it was because I was representing myself because I was so arrogant that I thought I was a master lawyer. And then when my legal team finally responded, they were inept and they were bad at their job because they waited to run the clock down to respond, and apparently Mr. Bad Lawyer. And then when her legal team showed up, they were big shots, hot shots, is what was said, because they'd done so many different types of law, and a different lawyer from Puerto Rico was coming. It was going to be a big deal, right? And then my case was hopeless, and I was getting buried, and it was blah, blah, blah. And then it started to change to, okay, he has high-powered lawyers. They've defended master rapists across the globe. Unfortunately, her lawyers are getting bad faith attacked, and now everybody's getting intimidated. Look at the changing. And now this fat fucking loser. Oh, I guess he's not part of the case, so can we say more about him? This fat fucking loser, right, is isn't it funny how inept her legal team is? Oh. And by the way, I'm just giving you, because I do pre-watch the future, okay? Just so you know, the spin that people are going to try to do, I'm going to go through this. This is going to be a 7-hour video on my YouTube, okay? I'm going to go through this case from start to finish, because holy fuck, all right? But the spin by all the end of this is going to be, Destiny only won this case on a technicality because he had high-powered lawyers, and he buried this poor girl under a mountain of vexatious motion or litigation. That's going to be what people will try to sell as the ending narrative for all of this.
The name is redacted, yes. The name is redacted. The avatar is not redacted.
And again, like, it's funny just because of the context of all of this and because I can bear it psychologically and financially. But like it truly is disgusting, right? Because again, this is a federal case. These are serious claims. A federal judge is going to have to sit here and read them. We do a magistrate hearing tomorrow, okay? There's resources of the state. Listen, lawyers get paid. They don't give a fuck, okay? My legal team, I'm sure they're happy. They get their money. I don't know about Jane Doe's legal team. I'm sure it's a good family favor they're cashing in on. But like, it's just a waste of like the state's time, of the federal government's time. It's a waste. And it's just like a joke to all of these people.
Now, it was going to be, like, let's be real. It was going to be obvious who it was just from the, like, it literally... Like,
no, it doesn't have to be obvious. That's a fucking lie. I can't watch his shit. Watching him and other people talk about this, like, the people that hate me are so brain broken in their analysis. It's so funny listening to the crazy legal theories that they spin to try to make it so that, like, actually, this filing is really good. This filing actually is really good for them. You got to watch, like, the next minute. It's everything these people say is so stupid.
Like, the quotes, like, referenced earlier on. Okay? Yeah. But I'm sorry. It's, like, it's just very, very, very funny that, like, they're like not saying the name, they're protecting the name. And I click on this, and it's my shit. But like, realistically,
like, you realize they've done this to like 5 other people in this case, right? I could maybe understand, maybe I could understand it happening once. But if you're making mistake after mistake, I'm sorry, you should recuse yourself, or tell the plaintiff that like you're not suitable for representing them in a case of this caliber, or in any federal case at all. Stick to, I don't know what law they do in Puerto Rico or whatever local jurisdiction you're in, or immigration sounded like what she specializes. Just do that. Stick to that.
There's no reason to suspect, or like, I don't need, I've said that to Pixie, but I told Pixie, I was like, I literally said, hey, I'm going to talk about that on stream. And then I said it live, like publicly, right? So realistically, I want my identity protected, but I don't need like, the pseudonym protected is whatever, right? Yeah.
Like what he's saying here, and again, I know these guys live in a separate world. This is child's play. This is not how the real world works, right? Men don't show up to court in a Guy Fawkes mask saying, Your Honor, it's okay that they know my video game name, but I would like to protect my real life name. No, in real life, in the big boy world, if you want to go to court, then your name is on the line. That's it. It has to be. Your reputation is on the line. Your testimony, the credibility of you as a person is on the line, because now you're in the big boy world, okay? Plaintiff initially filed this case after demanding $15 million from me, all right? You don't get to make those types of supporting claims behind a fat fucking video game avatar. Either stand tall on what you're saying, or do a big boy protective order and super fucking save all your shit or whatever. This half in, half out is bullshit.
Yeah, I mean, I let her know. I was like, hey, just so you know, that should have definitely been censored. That would have been insane not to censor it. If it wasn't somebody who had spoken publicly, right? So, yeah, that's like, if I'd spoken publicly on it, this is me asking to speak publicly on it, right? I'm just going to say, like, oh, I'm going to say that on stream. Oh, boy.
Can witnesses not remain anonymous? Obviously, the filers to reveal themselves, but I feel the witnesses should have some protection if it's more... No. There's exceptional circumstances where they can be anonymous, like in child sex crime cases, maybe. But no, you have a right to... Because imagine if like 10 people came out and supported Pixie, but they were all anonymous. How am I supposed to defend myself against claims? How How am I supposed to defend myself against claims if I don't know who's making any accusations against me? You can't do that. Pro tip, make sure to call the magistrate a magistrate judge. In my state, we have at least one magistrate who specifically said at a CLE she wants to be called a magistrate judge. I'll probably say Your Honor for everything. I'll ask my lawyer for all the guidance on that.
But I had a little laugh to
Well, they should have to reveal themselves to you, but just not to the public. Oh, sure, Cinema. You can do that easily. That's called filing under seal. But the problem is plaintiff's counsel that I don't know. I don't know where they practiced law at or what they do or if they're even real lawyers. I know that they're super ass mad about me criticizing their inability to understand the English language or basic rules of federal civil procedure. I know that that makes them very ass pained, but this is unacceptable behavior. Like, you should be cringing right now that some fucking retard music school dropout online is reading through your court filings and can see that you are clearly incapable and doing a disservice to both the federal court and to the client that you're supposedly representing. You're not qualified for the case. You're in way the fuck over your head, and no amount of lawyers at your firm flying to Texas for cancer or pneumonia sicknesses that you're having is an excuse for the disgusting negligence that you've shown or ineptitude that you've shown handling this case, in my opinion. But who the fuck am I guess, except the defendant. I guess in a way, what I really mean to say, let me be more concise. What I really mean to say is thank you, plaintiff's counsel. Thank you. That's what I mean to say. Truly, thank you. Make sure that next time you file the request for a page extension so you can have 20 pages to write about how mad you are about the mean things I say about you. I'm sorry. This is just so funny to me. Where is it? He refers to me as a disgusting fuck and repeatedly accuses me of grabbing random people to perjure themselves. Defendant accuses plaintiff's counsel of me of bad faith arguments, explicitly lying, and abuse of the court system. He spends a whole 30 minutes telling his followers that we have no understanding of the federal rules of civil procedure because we allegedly did not adhere to proper procedures by filing redacted declarations of the witnesses, along with the motion to file under seal. And then the stuff about Lauren. A post on Kiwi Farms. The defendant has also publicly doxed and attacked Lauren Hayden, a friend and potential witness of plaintiffs. Lauren is listed as an individual likely to have discoverable information on defendant's initial disclosures. The defendant has spread lies about Lauren and talked about how he would like to get her disbarred because she has been supportive of plaintiff. Sorry. Okay. Where were we? This is just quoting law for the... Mischaracterized legal filings and court orders. I did not mess that filing up. That is not true. That is not true. I can already, she's Joanne, I hear you. I can hear you clacking your word. And then at 7 hours and 27 minutes in his video, in a whiny voice, some call it on his stream, the straw man voice, he claimed I said things that I never actually did, and he made disparaging remarks about me. My God, I'm sorry. The proposed order is sufficiently narrow in scope, yes, because me not being allowed to say anything bad about a potential witness, which could literally be anybody, I guess, on the face of the earth. Wait, where's Leon? I'm just curious, because this could all be standard, like, crazy shit that just happens in legal filings. Have you guys seen this? Where's Jen or Leon? Where people are crying about the defendant talking mean about them? I'm sorry, I don't know. I'm making all these jokes, and then tomorrow I'm going to show up, and the magistrate judge's chair is going to spin, and it's going to be like, it's going to be fucking, oh Oh God, who was the one conservative lawyer guy with the beard, the facial hair? Who am I thinking of? Not Rakita. Not Good Logic. We used to debate this guy all the time, a long time ago. I don't know if I'd say all the time. Lecture Fan. Yeah, imagine it's Lecture Fan. Destiny! Oh no. I'm like, oh shit. Destiny. Well, well, well. Shit, I'm sorry. I doxed our address again, my bad. Blank has expressed fear of providing any further information after defendant publicly called for his death on the defendant's YouTube channel. Keep in mind again how disgusting this is, right? This guy has streamed for months. This guy has streamed for months covering all this shit. But he won't step up and testify? For plaintiff? So it's only to make money. It's to make money off of this because he's farming this. The same way that he farmed anybody else involved with this. The three other potential witnesses also believe that the defendant has committed crimes against them by disclosing intimate images of them without their consent, but they were afraid of pursuing legal action because of how he has publicly harassed and insulted me and anyone who has supported me, including my counsel. They were like, you have to include this. He attacked us too, remember? 3 of these witnesses have expressed to me fear that their physical well-being could even be put at risk if they attempt to pursue justice. Oh my God. Attached here too is Exhibit C is a true and correct copy of my conversation with one of those witnesses whose screen name is blank blank, where she communicates her fear of defendant. Exhibit. This is C. We already looked at all these, right? Is this a Twitter message? Stephen Bonnell has abused his position of power and community to gain favor and harass people in the past. I find his actions deplorable and terrifying. I will never feel comfortable being a witness in this case against Stephen unless my identity is protected. I fear for my family, friends, and my current and future careers. Without protection, I am almost certain I will receive harassment and doxing from his community. Is this a single DM with no... This is a single DM, right? Because unless they white boxed all their responses here, it looks like they got one message from this person. Oh, a text, I'm sorry, not a DM. I also like, I like how there's no date on it. Wait, what is today? Monday? Friday? On the 30th. When did we file our shit? Was it on the 30th? On the 30th. Do you think she asked? I bet this is fake. I am accusing them. I bet this is a fake message. I don't believe this. It reads like a... And clearly, opposing counsel and plaintiff are dumb enough to fake something in the stupidest way possible. Nice typed out message with proper capital. Yeah. Is this one anonymous too? Yep. I have no record of any of these people. They didn't forward us any like unredacted filings at all. They didn't send us any information about any of these people. There's literally nothing. Yeah, like who says Stephen Bonnell? Seriously? Somebody's saying that it's like an affidavit, but bullshit. If you want to have them fill out an affidavit or to fill one out and sign it, then have them do that. Fill out an affidavit and sign it. This is a stage text though. Also, why are you filing redacted screen names? If you're filing a redacted version, why are you not even putting their name? Whose screen name is? Almost every individual I communicated with expressed not only their disgust for defendant's actions, but also their reluctance to speak out publicly due to their concern and fear of defendant retaliating against them. Why didn't you get all of these statements then prior to filing the complaint? Signed today. Nice. Why are there no previous text in that screenshot? Like I said, I think that the Destiny Vars database. Isn't it super fucked up to file this motion the day before the hearing too? It means your lawyers don't have a chance to draft it. Yeah, and it was intentional too, because I think normally it takes these guys forever to file responses, and they had until the 6th, but they made sure to get this one in tonight. They got this one in on time. What, is any of this anything? File under seal. Plaintiff requests that the seal remain in place for the duration of the litigation, including any appeals to ensure ongoing protection of the identities of the witnesses. This duration is consistent with the need to prevent further emotional psychological harm to plaintiff and the individuals referenced in her declaration, as supported by Doe Williams v. Williams. What do you think this case looked like? Order of dismissing case. What happened? Hold on. Mississippi Southern District Court login. I can't use Pacer? I have to have a login for their particular thing? No way, right? Oh, I think I can't. Oh, fuck, I'm too lazy. Fuck, god damn it. Or wait, am I logged in over here? Oh, I do. Mississippi Southern District Court login. Are you serious? There's no way this is... Log in. Can I use my... Oh no, I can. Okay. This case got dismissed. Why would they cited a losing case? I mean, they just need evidence of the protective order, obviously, but. Hold on. Plaintiff is an adult resident here. Defendant, blah, blah, blah. Defendant, blah, blah, blah. Facts. Plaintiff went to dinner with the Williams in November of 2022. Oh, this person sued a couple, I think. The two were friends and business colleagues prior to the dinner. They had several drinks at dinner and became intoxicated. They went back to this person's home where plaintiff had some recollection of the events. They became aware of a sexual encounter. They could not recall everything that happened. Plaintiff had never been with a female before, nor had any interest in being with a female. No other Jesus Christ. Noticing a phone in Williams' hand that night, plaintiff asked Williams the following morning if she recorded anything that took place. Williams replied that she did indeed record sex between the two of them. Plaintiff told her to delete the video. Williams falsely told plaintiff she had nothing to worry about, as her face was not in the video. The reassurance meant little, as Williams said she was not going to delete the video, but instead would keep it in the vault. Plaintiff again told Williams that plaintiff would feel better if the video was deleted. Plaintiff asked Williams to delete the video, but she refused to do so. Plaintiff discovered Williams did not delete the video in or about May 3rd, 2023. At the time, Williams casually mentioned the wife and of her boyfriend, Brad, blah, 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 that found the video on her husband's email and watched it. Horrified, she asked Williams, what video? Williams said that she sent this guy the video and that contrary to her earlier claim, it indeed included plaintiff's face in said video. Plaintiff listened in a state of shock as she realized video of the non-consensual act was being passed around the Mississippi Highway Patrol, where both defendants worked at the time. Plaintiff thought the video was deleted. Unfortunately for plaintiff, Williams, I wonder why this got dismissed or what happened. Okay. Summons issued as to these. Sorry, hold on. Fuck. Here, I'll read this later. I'm curious why this got dismissed. Are we done? Was that everything for my bullshit? Motion for leave to file redacted evidence in support of the Oh! We have evidence from this anonymous person. Oh boy. Okay, this is the only witness keeping the whole case alive. This is the big one, boys. Respectfully moves this court for leave to submit evidence in redacted form and for leave to file under seal the unredacted evidence in support of the declaration of this person, who is filed on May 2nd, 2025. Plaintiff files this, along with the plaintiff files motion to leave declaration, now seeks court's permission to file redacted evidence in support of the declaration. Oh. Hold on, what? There's no way that this is retarded as fuck, but in the instant case, good cause for sealing exhibit A is unequivocally established as the exhibit contains highly sensitive details of private, sexually explicit acts implicating the substantial privacy rights of the declarant and other individuals. Public disclosure of their identities would expose the declarant to harassment or retaliation. Additionally, exhibit A helps establish offense violations when used supporting. By the way, Destiny sends me sex tapes all the time, and he thinks, I don't know, the girl's in them, but I have videos of him fucking... Oh, thankfully we got... Okay, and we censored her name. This doesn't even exist. And Pixie, like, Lympheo, he just sent me another one, haven't opened it. What? Why not post this person says We don't know who this is. Okay. Even though they accidentally also named the file, they put her first name in the file name. Bro! Where's the message of me sending her the thing? This is... I don't even know if this would be hearsay. I don't even know what the fuck this is. What do we... Okay. It is hearsay, but you can sometimes rely on hearsay in support of interlocutory applications. I don't know what that has to do with anything. This declarant claimed that she had logs of me supposedly sending her these things, despite the fact that I deleted them to hide them. So why not just post that? There's also a message missing in the middle of those two. It's grayed out as the same color. Oh, you're right. And so that's not redacted. That's just doctored. Because they're hiding stuff here. If they wanted to hide something here, they should redact it. It should be redacted like in these black boxes, not doctored. Okay.